Welcome to Gracefully Graying. I'm your host, Attorney Henry Gornbein. Please go to our YouTube channel and also visit Gracefully Graying to see this excellent video with Judge Lisa Neilson and all of our other shows. Today on Gracefully Graying, I'm pleased to welcome as my guest Wayne County Family Court Judge Lisa Neilson as we discuss issues involving grandparent visitation as well as the Great Divorce. Judge Neilson, welcome to Gracefully Graying.
Henry, thank you for having me.
First of all, Judge Neilson, tell us a little bit about the areas of law that you cover as a family court judge.
Sure. So we cover domestic with minor children, so divorces with minor children, divorces without minor children, so either they didn't have children or they're adults, custody, parenting time, support. We establish paternity, in other words, establish the legal father of a child. We also have jurisdiction over parties who want to enter into separate maintenance judgments. We also do personal protection orders and domestic violence issues. And then we do post-judgment proceedings where we're enforcing all the orders of the court in those cases.
Now, do you have cases where grandparents are trying to see their children?
We do. Now, there's probably way more grandparents out there than we see who actually formally file motions in the court. But where a parent or parents are excluding grandparents from minor child's life, we do have filings in the court, and those are properly in the family court.
Let's go through some of their rights. First of all, Judge Neilson, what rights do grandparents have if they are trying to see their grandchildren and the parents are still married?
So if the parents are married and there is no existing custody case before the court, the court can't help them. Grandparents only, pursuant to the Child Custody Act, grandparents only have rights to request grandparenting time in certain situations to seek an order for grandparenting time. If there is a custody dispute in the court involving the parents, whether or not be through a divorce or if the parents are unmarried and they have a custody dispute, that opens the door for the grandparents to be able to file a motion in the court. But there has to be an existing case already filed in the court.
What if the parents were never married? Does that change the scenario at all?
So if there is never married parents and there is a custody action, that would be a DC, a custody action, or a support case, a DS case. In those cases, if there is an existing case between the parents, yes, that opens the door for the grandparents to be able to have the right to file a motion in the court.
Another situation which I've handled over the years is if there's a divorce or a death of one of the parents, what rights do the grandparents have to see their grandchildren in that scenario?
So let me start by saying there's no statute authority in the state of Michigan that gives a third party, even a grandparent, standing to seek custody if that party doesn't already have a substantive right to custody and there's no custody dispute pending in the court. In a situation where if there was a custody dispute between parents, unmarried or even married, and the court has jurisdiction over those parties and the minor child, and one of the parents dies, that is a situation where the grandparents may have a right to exercise their right to seek grandparenting time through that existing case.
Now, Judge Neilson, when you are dealing with grandparent issues and they're standing due to the death of a parent or a divorce, what are the things that you are looking at when you are trying to make a decision?
So the grandparent generally in that point is coming before the court because they're being excluded from the child's life and they feel that they would benefit that child's life by being involved. In those cases, they would file a motion to intervene in the pre-existing case. And presumably the court awarded custody to the parent who has custody of the child. So we run into what is called the fit parent presumption, right? So the court has already awarded custody to a parent. A grandparent is coming in and saying, I'm being excluded from this child's life, and I want the court to order that parent to provide me parenting time. But the grandparents then have to rebut the fit parent presumption. By preponderance of the evidence that the parent's decision to deny the grandparent parenting time creates a substantial risk of harm to the child's mental, physical, or emotional well-being.
So it sounds like it's an uphill battle.
I think it's probably fair to say it sounds like an uphill battle, and oftentimes it is an uphill battle, and it should be, right? So the Child Custody Act recognizes that parents have a constitutional right to raise their child, and you're presumed to be a fit parent, right? So starting with that as the starting point, there are situations, and there are always case-by-case situations in these cases, often very emotionally charged, where grandparents are really feeling threatened that they're not going to have involvement in their grandchild's life, and a parent being threatened by thinking that a grandparent is trying to impose their will on their parenting style and their lives. So it is difficult. And so there are many times where it is an uphill battle, because this area of law is very well settled in Michigan, and there are very specific steps pursuant to the Child Custody Act that the grandparent must go through, and very specific steps and analysis that the court must go through to even allow for the court to proceed on the motions. Generally speaking, it's a motion to intervene in a pre-existing case. At this point, the court has to make a determination if we presume that all the filings are correct and all the affidavits that need to be filed with the court have been filed. At that point, the attack really is, and it is an attack on the parental fitness of the parent who's excluding the grandparent from the child's life.
Judge Neilson, how should a litigant show the importance of a grandparent in a child's life?
So, I think that listen, I have 7 grandchildren, and I just, obviously my heart goes out to any grandparent who has to come to court and litigate. I would say that the most important thing is to try to mend broken fences, is to try to get involved with a family therapist, is to try to get to the root cause of why you're being excluded from that child's life, and also try to show support, lack of judgment, and try not to act in a threatening manner, but just really look at what is best for this child. Sometimes it's not best for the child that you be involved as much as you want to be involved. And that if you have a fit parent, that's that parent's right to assert that privilege.
What are some of the statutory hurdles? I mean, I've dealt with them. I've won some cases over the years, and I've lost many because it's really an uphill battle. But tell us about some of the statutory hurdles that a grandparent has to go through in order to get some visitation in a grandchild's life where there's opposition.
So in order to, first of all, the filings are very specific, and the motions to intervene must be very specific. You have to follow the law, and the statute is very, very clear. Like I said, it's very well set standard in Michigan. But if you presume that all the filings are correct and it's before the court, the grandparent has to rebut the fit parent presumption. The grandparent must prove that the parent is not a fit parent, and the fit parent is defined as a parent who adequately cares for his or her child. So that's a big presumption, right? And so what you're doing is you're having to come to court and really tell the court that the parent that is excluding you from the child's life is not making a decision that is one that is preserving that child's mental, emotional, or emotional health, and is not adequately caring for that child. That's a lot, and it's very much like, as you've experienced and what you've gone through and what I witnessed are, the most contentious of custody cases this could turn into. So if you're dealing with a child who's either gone through the litigation, a custody litigation with his own parents or her own parents, or a death of a parent, you've already got a child who's gone through some sort of trauma, a lot of changes in the parent structure in their household. So if you've got a child who's already gone through that, now you're asking that child to go through it again, only with grandparents, right? So it's something that has to be taken very seriously. You have to, if you're going to pursue as a grandparenting visitation, parenting time, you really have to understand what you're going to have to prove to the court, which means you're going to have to say not nice things about the parent who is parenting your child and who's excluding you from the child's life.
Tell us about some situations you've had in court. And I'm thinking back to cases I've had where often it was triggered sometimes by a divorce, but often by a death of a parent. And then the grandparents have lost a son or daughter and they had a regular relationship with the grandchildren. Sometimes the grandchildren would be there, you know, every other weekend, sometimes more, spending a lot of holidays, and they don't want to be excluded, but there's bad blood between the grandparents and the surviving parent. So what do you do?
Yeah, so that's the thing though, right? So the Child Custody Act doesn't demand that a fit parent, be a perfect parent, just that they be a parent. So they have a constitutional fundamental right to parent their child, to make the care, custody, and management decisions affecting the well-being of their child, which doesn't necessarily mean that being a grandma and grandpa having access to them, they don't have to believe that that is in their best interest. You also are dealing with, the history of the parties stuff that comes in forward into the case. So the reason that there's bad blood or hard feelings, or why your love for this grandchild cannot be expressed more freely and openly. I think that really the challenges in these cases is really to really try to mend and heal before you really go down that path of having a full-on custody trial and have this child go through what this child's got to go through. I had a situation which this child was very loved because both maternal grandparents and paternal grandparents filed grandparenting time motions in my court, all properly filed. And it turned out that both very young parents of this, they were unmarried parents, very young child. They both had a substance abuse issue, and both sets of grandparents felt that they were the better grandparent to take custody, actually was custody of the minor child, and provide for supervised parenting time with the parents. So while this child was full of all these parents who loved him, it was going to be quite an effort to figure out where to do with this child and where best this child was going to be able to be placed. I think I never had to make the fit parent finding whether or not these parents were fit, but they certainly didn't appear to be on the face of things. And it did seem like this child was going to need to go somewhere else other than with the parents at this time. In that instance, I appointed a really, really good guardian ad litem, right? So a guardian ad litem is really useful in situations where you're involving these type of things, when you're involving issues that are very sensitive, that really need a thorough understanding. And in this instance, the guardian ad litem was able to work with all the parties, and the matter got dismissed after everyone just came to a consensus on what to do with this little guy. It was a little guy. I think he was about 10 years old. So I didn't have to end up having to make the fit parent finding, or no one had to sit in court and say horrible things about the parents and make everyone feel worse. It turned out to be a real positive for that child. So the filing itself generated a robust discussion, and the involvement from the court was very minimal. It was enough just to get that guardian ad litem in there working with the families, getting them to the therapists that really needed to be front and center and working with this family to mend this family, and it worked.
Tell us exactly what is a guardian ad litem for our viewers who might not know.
Sure. So a guardian ad litem flows from a statutory statute, and it's a guardian ad litem really acts as the ears and eyes of the court. The guardian ad litem works in the best interest of the minor children, so investigates and reports and makes recommendations to the court in the best interest of the minor children or child. And in this instance, this is the this is the type of case that is primed for a guardian ad litem. The guardian ad litem will talk to the parents, the grandparents, the child, teachers, friends, whoever, and be able to really formulate a good idea for the court, really what's going on here, and make recommendations in the best interest of the minor child. Because at the end of the day, it's not about the mom and dad, it's not about grandma and grandpa, it really is about this child.
And in the case that you were talking about a moment ago, what was the end result? Were both grandparents actively involved?
Not only that, but the parents took it more seriously too, and the parents themselves turned to their parents to get help. So it turned out to be the perfect ending to a case where the parents, the parents of the child recognized that they really had a serious issue, started to take that very seriously, and the grandparents came together. And so this child ended up having one set of grandparents lived in Florida, one in Michigan. This child travels back and forth and has both parents still in his life. So it turned out to be a really good thing for all involved.
What advice would you give to a grandparent who has been cut out from his or her grandchild's life?
So I would say that if it's something, first of all, if you think you're going to file anything with the court, you want to make sure you're filing and meeting the criteria pursuant to statute. So you would want to find a family law attorney who knows this area with all the intricacies included and involved in the statutes and the statutory scheme pursuant to the Child Custody Act that apply with grandparenting, parenting time. It's limited. Being able to get the assistance and the relief that you're looking for from the court. It is, as you said, it is an uphill battle most of the time. It's not that cut and dry. And there is a fit parent presumption, and the constitutional right to raise your children is front and center. So having said that, my advice is know what the litigation world looks like, know what you will need to prove before you make a filing, know it, educate yourself, inform yourself, but more importantly, try to figure out what's going on and what you need to do to make amends to heal the family that needs healing. And that would mean offering support, being present, being helpful, making sure that you're not a threatening presence in anyone's life. Doing what you need to do to make sure that you authentically are just trying to get the message across that you simply want to be involved in your grandchild's life and that it will benefit the grandchild, not just you, but also the grandchild.
Let's move to another area. And a lot of your docket deals with divorce. And in many situations, you're dealing with people who are in their 50s, 60s, sometimes 70s, who are trying to unravel and get out of a long-term marriage. And we call this area the gray divorce. Tell us about some of the situations that you've been involved in.
So I can tell you that I am seeing during this pandemic, we are seeing more and more filings of what you are calling gray divorces. So this is becoming more and more of an issue that the court is seeing. What I am seeing with these divorces are issues very particular to this segment of society. So if you've got a long-term marriage and you're older, you are looking at division of maybe substantial assets, retirement accounts, and maybe significant debt, maybe households. You're also maybe looking at disrupting your child's lives, your adult children's lives, maybe not making them happy. Sometimes you see them picking sides. Sometimes you've got health issues that are implicated. And many times what I'm seeing is that you've got folks who are no longer earning income. And so their income is it's set. And so sometimes what we're seeing is that income that was just enough to cover one household now needs to cover expenses and carrying costs of two households. And generally speaking, that means they're going to be disadvantaged. At least one is disadvantaged, more so it seems than the other sometimes. Sometimes you find that the children get involved, adult children get involved and have to assist their parents through their lives, meeting their needs, even moving in with the children. I think that what I'm seeing is that maybe people are acting out of, I don't know if the pandemic is just, people have lost their patience and people are stressed. And I think that folks are reacting in a manner, obviously, because I'm seeing more filings in a manner where they do want to separate from a spouse at this time. And I don't know that all the implications, financial, health, and the benefits are all being looked at when the filing is made. A lot of times I'm seeing filings are made and then filings are dismissed.
Do you have any suggestions for our viewers with regard to the area of what we call the gray divorce?
I do. I think that ideally you would want to, before you file anything, you would want to talk to financial planners. You would want to engage your family. I think you really need to know and educate yourself. What does divorcing mean? What does divorcing mean now? And certainly on a gray divorce, what does that mean? Am I on a fixed income? Am I going to be able to meet my needs? And I think that it's really important. Some people are willing to change their life status and make drastic changes in their life. And as long as they know that, then I think that's fine. But I think that a lot of people are probably taken by surprise at the effect, the negative effect and consequences of unwinding a marriage, a long-term marriage later in life.
Judge Neilson, as we're doing this video, we've been under Zoom for about a year now. And tell us about some of your experiences with Zoom in your court.
So I'm a fan. I'm a big fan of Zoom. I think that when we shut down our court, so I'll talk specifically about the Wayne County Family Court Domestic Division. When we shut down, we have 11 judges, and then we have the friend of the court and the staff. But we were very cognitive of the fact that we were going to have to pivot and innovate and meet some challenges about how to get back up and running, even though we weren't going to be in the office. And that was with a sense of urgency. So I would say from day one, we all came home and started figuring out this scary thing called Zoom. I can't tell you how many seminars I attended through the National Center for State Courts or through other states and through our own state, who, by the way, is a leader. The state of Michigan is absolutely a leader nationwide in technology and in making sure that access to courts is maintained and improved upon. But it was, we came back to work servicing, back on our docket, servicing litigants on May 11th. So we were gone. And during the time we were down, we were meeting daily, trying to figure out how to innovate, how to meet the challenges of Zoom, how to get our docket, and how to get everything online so that we could continue the docket. Having said that, there's been challenges, certainly. The challenges are a learning curve for all of us. The litigants, I can tell you, have met the challenge head on and are doing really well. A year later, I can tell you that I don't believe I've ever experienced, I've never heard from anyone that they could not attend a Zoom hearing because they didn't have a phone or the ability to access, which was really one of the concerns early on. But I've never heard that. Having said that, people do miss, at this point, instead of having a docket call that starts at 8:30, and everyone just sits in my courtroom, I have appointments. So if you have a 9 o'clock appointment, I need you there at 9. If I have a 9:15, I need you there at 9:15. That doesn't always work. And on both sides, technology does get the better of us, and we don't always get to have our hearing when we want to.
But overall, it's been positive. And, hopefully we're getting out of this pandemic. But I did an interview recently with Chief Justice for the Supreme Court, Justice Bridget McCormick, and she's saying that a lot of Zoom is going to become the new norm. And do you agree with this?
Yeah, I think that, I think it's pretty clear that, listen, there was a sense of urgency and we had no choice but to face this head on with this global pandemic, and it's worked. I can't imagine how much time this would have taken in our old world when it was the old normal, how many committees would have been formed, how much thought would have gone into getting us to where we are today. So I think out of this crisis, one of the silver linings out of this pandemic has been that the innovation and the practices that are in place right now were developed because they had to be, out of a sense of urgency, out of a sense of crisis. And now what's going to happen, I do believe, is that now that the data is going to be reviewed, we're collaborating with other states, with other jurisdictions to see what works, what doesn't work. And this is going to get fine-tuned into so that we have best practices available. The other thing I think that's brought to the forefront is that I think that it's really, this is the time to ensure that the self-represented litigants, who we have many of in our court, and the underrepresented litigants, it's time for, and this is a perfect opportunity to be able to get them the legal assistance that they require so that they can navigate the court and get their needs met. And I think that is going hand in hand with this virtual world we're living in.
What advice would you give to litigants who are having trouble with the technology of Zoom?
Oh, deep breathe, deep breathe, be patient, and be prepared. One of the things that I think across the board, Zoom requires preparedness. So that goes to litigants, that goes to attorneys. Know that your device works, practice with it. For litigants, if you have a youngster living in your house, I don't care if they're 5, they'll show you how to do it. So there's always a will and a way to get onto Zoom. Absolutely.
What are some of your highlights that you'd like to share with us from your career as a judge?
So I have to say that, thank you for asking that. I'm going to go backwards. One of my highlights is being part of this process, this innovative process where we're meeting this challenge head on. I'm so proud to be part of this process in making sure that access to justice, making sure that our litigants are being heard. I'm so proud of being part of the team that has made Wayne County Family Court so accessible. We didn't take a break. We just kept going behind the scenes, in front of the scenes. Everyone was just very concerned about ensuring that the folks of Wayne County are going to be heard and that their kids and themselves, their needs were going to be met. And I'm so proud of that. And to me, it's big. When I look at what we've accomplished over this year, I'm just very proud to be part of that, Henry. Having said that, I'm looking forward to where it's going to take us and the changes that are going to be implemented as a result. And I'm proud of being part of the change that's going to fully elevate the court process and include the underrepresented, the self-represented. I think that there's a real momentum now to make sure that there's access to justice and it's equal for all.
Well stated. We're running out of time. Are there some takeaways you would like to share with us before we sign off, Judge Neilson?
So I think that we go back to the grandparents' rights, and it is very clear that natural parents, a fit parent, has the constitutional right to parent their child. So for all those grandparents out there who want to not be excluded from their grandchild's life, they need to establish and maintain the healthiest relationship they can, always with both parents. They don't have to like them. They don't have to agree with them, but don't judge them and don't yourself exclude them from your life. So the worst thing you could do is exclude the parent of your grandchildren's from your life. So you have to do everything you can and put the child's needs before your own. And I think that's the most important thing. And certainly your heart, when you hear about the death of a parent, if your child has died and you are grieving the loss of your child and you are excluded from that child's offspring, certainly that brings with it such sadness, certainly for the court, just to hear it. At that point, if you have to engage in the litigation process, please engage with someone who's a specialist in the area, who can give you good advice. And I'm always a big fan of guardian ad litem in this situation. This is an area where alternative dispute resolution is really, really important. To collaborate as much as possible in the best interest of the minor children is key. As far as gray divorces, they are, I believe, becoming more common. And there's, as in any litigation, there is a whole spectrum of cases that appear before us where you've got folks with ample resources and assets who are going to be just fine living separately, probably better. And then you've got others who this is actually going to put them in a state of poverty and despair, and you hope that they're fully aware of the implications of a divorce.
Judge Lisa Neilson, we are out of time. I want to thank you so much for being our guest on Gracefully Graying. Again, I want to remind our viewers that we have our YouTube channel. Please watch this and our other videos, as well as visiting our Gracefully Graying website at gracefullygraying.com. We have a lot of information to share. Please like it and share it. And again, Judge Neilson, I want to thank you so much for being our guest on Gracefully Graying, and I want to thank our viewers for watching Gracefully Graying.